The criminal charges against Derek Chauvin, the officer accused of killing George Floyd in Minneapolis on May 25th of 2020, have been upgraded from third-degree murder and second-degree manslaughter to second-degree murder and second-degree manslaughter, and the other 3 officers have been charged as accessories to the second-degree murder and second-degree manslaughter charges. What does this mean? How does this work in Minnesota law? Let's talk about it. Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. Today, we're talking about Derek Chauvin and the death of George Floyd as protests and riots continue, not only in Minneapolis, but in several cities across the United States. We now have an update to the original charge of third-degree murder to now being charged with second-degree murder for Derek Chauvin, and the other 3 officers have been arrested as accessories to the second-degree murder and second-degree manslaughter charges. So we're going to take a quick look at an article that talks about this, just a couple paragraphs, and then I'll go into the legal aspects a little bit more. So here we go. Prosecutors on Wednesday filed a tougher charge against the police officer at the center of the George Floyd case and charged 3 other officers delivering a victory to protesters, galvanized by a death that roused racial tensions and unleashed coast-to-coast unrest. The most serious charge was filed against Derek Chauvin, who was caught on video pressing his knee to Floyd's neck and must now defend himself against an accusation of second-degree murder. The 3 other officers at the scene, Thomas Lane, Jae Kyung, and Tu Tel, were charged with aiding and abetting second-degree murder and second-degree manslaughter. All 4 were fired last week. The new charges were sought by Minnesota Attorney General Keith Ellison, who called the protests unleashed by the death dramatic and necessary and said Floyd should be here and he is not. His life had value and we will seek justice, said Ellison, who cautioned that winning convictions would be hard and said the public pressure had no bearing on his decisions. Winning convictions will be hard, but I think public pressure absolutely had a bearing on his decision. Benjamin Crump, an attorney for the Floyd's family, called it a bittersweet moment and a significant step forward on the road to justice. Crump said Ellison told the family he would continue his investigation into Floyd's death and upgrade the charge to first-degree murder if warranted. Okay, let me be very clear on something. The evidence that we have now does not support in any way a first-degree murder charge, and a first-degree murder charge in this case is a quick path to an acquittal for Derek Chauvin. It's a bad plan. We would need significant additional evidence that is not available to the public at this time to support anything even coming close to first-degree murder. First-degree murder requires an intent to kill the person and premeditated thought leading to that intentional killing. So some level of planning or desire for the person's death prior to the actual infliction of the death that must also be intentional must all occur. Right now, we have no evidence of any premeditation, and we have tenuous at best evidence of intent. And I would argue that we have no evidence of an intentional killing. Right now, as the second-degree murder charge is a second-degree unintentional killing charge, I think the county and state still agree with me on that. That being said, there's a difference between third-degree murder and second-degree murder, and I need to talk very briefly about those. So Derek Chauvin is currently charged with second-degree unintentional killing. To support a second-degree unintentional killing, the death has to be the result of some other existing felony. Now, the only felony I can think of that they're trying to pin on Derek Chauvin as the underlying factual basis for the second-degree murder charge would be a felony assault, which would be an intent to cause basically great bodily injury or serious bodily injury to George Floyd and then inflicting that bodily injury upon him. You can argue that he inflicted bodily injury upon George Floyd because he's dead, right? That's a pretty easy argument that bodily injury was inflicted. But assault in Minnesota is still a crime of intent. You can't accidentally assault someone. You must intend to convey the threat of the harm or intend to actually convey the harm and then do it. So what the theory would be that the placing of the knee on the neck of George Floyd was an intentional infliction of harm sufficient to support an assault conviction that ended up with the death of George Floyd. I don't think that, based on the evidence that is publicly available at the time of recording this video, that they can do that. I don't think they can support that charge. They just don't have evidence that I've seen that is sufficient to support an intentional act of harm. What I think they do have is an intentional act of restraint as a police officer that then goes beyond the bounds of what is acceptable. And this is why I think the third-degree murder charge is the appropriate charge. A third-degree murder charge can be, they must prove that there was a creation of an imminent danger to others, and that imminent danger was carried out with what's called a depraved mind, which just means a wanton or reckless disregard for the value of human life. I think that charge will be the one that sticks. Even if they run through with the second-degree charge, I think they will convict on a third-degree murder charge if they get a murder charge at all, again, based on the evidence that's available today. I think we can show that Derek Chauvin created an imminently dangerous situation for George Floyd by putting his knee on the back of his neck in some semblance of a police restraint. Okay, I think we can show that he did that, and I think we can show that he acted with a reckless disregard for the life of George Floyd when his fellow officer said, I checked his pulse, I can't find his pulse, maybe we should turn him on his side. And he says, no, we're going to keep him right here, and proceeds to keep his knee on the neck of George Floyd for another 2.5 to 3 minutes. What I don't think any of those actions show is an intent to cause harm. And as weird as it is, Derek Chauvin's sort of mocking tone towards George Floyd don't evidence harm being the intentional outcome. It seems like he legitimately thinks he's restraining him for some sort of purpose, and that restraint is necessary for the situation. They've already said that they believed he was resisting arrest. They're going to continue with that argument through the defense of the thing. We can look at the video all day and say, I don't think he was resisting, but they're going to assert as officers a belief in him resisting their reasonable attempts to get him into a squad car and having a necessity to restrain him, that's their perception. And they're not going to be able to easily show that intent based on the evidence that's out there. They would need evidence of him saying, you know, I'm going to hurt you, I'm going to do this, some sort of statement from Chauvin that runs contrary to the other statements he made, which just seem to evince an intent to restrain him. That's going to be the key. And if they can't show that, I think they have a lot of trouble getting to that second-degree murder conviction. Now, I've seen some people out there saying the third-degree murder conviction won't stick because they directed all of their activity towards one person. And there's some case law that suggests that that's how third-degree murder works in Minnesota. Interestingly, there is conflicting case law that is still good law. Both of these are still good law that suggests that even if all of the action is directed towards one person, it can still sustain a third-degree murder charge. In fact, there are convictions upheld for third-degree murder charges where one person fired 2 bullets directly into another person and killed them. And that was considered an unintentional killing. And it was directed at that person. So we have that on the books. And more importantly, just last year, in Hennepin County, the Hennepin County prosecutors secured a third-degree murder charge and conviction against Mohammed Noor. I don't know how to pronounce his last name. The Minneapolis police officer who killed Justine Demond. They actually had a similar fact pattern that we have here as far as how the case progressed. He was initially charged with third-degree murder and second-degree manslaughter. And if you want to know why, Mike Freeman, the county attorney in Hennepin County, charged the Derek Chauvin with the same charges, is because that's what won last time. That's the charges that won against a police officer last time. It's really hard to convince a jury that a police officer intentionally killed or harmed someone. But you can convince a jury that a police officer's reckless actions created a situation that was so dangerous and so indifferent to human life that it ended up with the death of a person. They did that. And interestingly, they initially charged him with a third-degree murder, but they upgraded it later to a second-degree murder charge and failed on that charge, despite the fact that he pulled a gun, pointed it at Justine Demond, fired it, and killed her. So again, anyone saying that it is impossible to convict on third-degree murder when all of the action is directed towards one person is frankly incorrect. It's a half-baked approach to the jurisprudence around third-degree murder. There are specific murder cases that involve all of the action directed towards one person, but an imminently dangerous situation was created, and then a reckless disregard for human life was carried out in that situation, and it led to the death of another person that was not intentional. That makes the third-degree murder charge the reasonable and prudent charge to have. No amount of rioting will change the facts in this case, and that is a problem for Keith Ellison and, of course, the family attorney Ben Crump, who is asking for an escalation to first-degree murder. They still would have to prove that George Floyd was killed intentionally by Derek Chauvin for first-degree murder, or unintentionally, but after an intent to cause harm for second-degree murder. And right now, some of the body cam footage has not been released yet, so we don't know about that. But right now, I cannot see where they get intent to cause harm or death from any of the evidence that's available. Maybe you guys see it differently. If you do, tell me down in the comments. I love to see your thoughts on this, and I hope you have learned a little bit about the different murder charges that are involved in this case, and just take what I've said about the murder charges, how they have to prove it, and apply the facts as you know them to the charge, and that's how you can help kind of reconcile what's going on with your own mind and make up your own decisions. This is just my opinion. Of course, I am a defense attorney in Minnesota, so I'm looking at it through that lens. But you guys go ahead and tell me what you think. Hope this video helps. Have a good day. Don't riot. Peace. Always peace.